I know this is becomes quite political. People on both sides have got very strong views on this. But the job of the courts ultimately is to try to interpret the law to make it work for the benefit of those in front of them. And so we're at this first instance, if you like, attack on the process of passing legislation. Legislation is not even actually actively enforced. And the position of the freeholders is to say, well, look, the mere prospect of this legislation sitting there has actually damaged the value of our assets.
Welcome to Listen Without Prejudice, the podcast from Bishop and Sewell. Each episode brings you expert insights, practical advice, and real stories from one of London's leading law firms. From property and private client matters to business law, family, and dispute resolution, we're here to inform, guide, and inspire. Let's get started.
Hello, and welcome to the Bishop and Sewell podcast. As always, I'm Charlie Davidson, Senior Associate in the Property Department, and I'm here with some man called Mr. Mark Chick, who also happens to be the leading expert in leasehold law at our firm in, dare I say, the City of London?
Welcome, Charlie. Well, that's too kind an introduction, but I've been known to extend the odd lease in my time. So.
Well, I've been asked to sort of host this podcast on Leasehold Reform Update. Now, obviously, leaseholds over 100 years, archaic, so I take it it's going to be a very quick podcast. Nothing's happening at all.
Absolutely, Charlie. Nothing's going on whatsoever, apart from a few little things like a little judicial review that's been going on in the High Court about the legislation.
But Mark, that's law.
Yes,
that's law.
I know. Well, this is a legal podcast, so they told me. So you might remember back in 2024, the previous government passed this thing called the Leasehold and Freehold Reform Act 2024.
Got it just under the wire.
A own piece of statute. Yes, in the closing moments of the last Parliament, just sneaked through. With cross-party support, I'm pleased to say as well. However, none of the provisions of that act have really been enacted apart from a few basic points we've covered in some previous episodes around reforming the law and the right to manage. The big pieces as regards enfranchisement and what people are interested in, apart from the abolition of the 2-year rule, are all sitting there on the statute books waiting to come in. So the big ticket question for people wanting to extend their lease or buy their freehold is really, should I do this? Should I wait? Where are we with all of that? And you might ask yourself, why has this legislation not come into force yet? Well, one of the reasons for that is because there's been a judicial review.
Do we want to explain what judicial review is, though, to listeners at home?
Do that, yes, unless they're immediately familiar with that. So a judicial review, and perhaps you give me your answer on this, Charlie, as well. If a government makes a decision which is not necessarily administratively correct or not being made in following correct protocols, it is possible to have a review of that decision itself. The government may have acted unreasonably in coming about with the decision it's taking. So where we are with this legislation at the moment is that there is a challenge brought in the High Court by 6 freeholders who have effectively challenged the basis of the legislation, saying that simply passing legislation and even having it sitting there on the statute books infringes their human rights.
But of course, most people will be familiar with human rights to life, privacy, though, but this one in particular is something a bit more basic we don't often hear about, which is private property.
Yeah, absolutely, yeah. The human right to property. So, I mean, everyone has a right to property and peacefully enjoy their possessions under Article 1, Protocol 1 of the European Convention on Human Rights. And I think where this comes from is that those property rights, as enshrined as they are, intrinsic as they are within our legal system, will apply equally to freeholders and to leaseholders, and indeed even to bodies corporate. So the principles of the law should be applied fairly and equally across the board. And the human rights point is that effectively everyone should be able to peacefully enjoy their possessions without interference from the state. Now, here's a situation where the state has sought to regulate leasehold because leaseholders cause people problems. The government has sought to implement quite political terms of reference in terms of changing things, shifting the dial in favour of the leaseholders. And you can say that, without sort of summarising all of the arguments, the essential point is that from a human rights point of view, it would be okay to control the use of those assets. That would be fine. But if you go so far in your control of them, you actually deprive them of all value, then that's going to be an abuse of the human rights of the person to whom you're trying to regulate the position on. And there are some precedents on this. So there's a case called Lindheim, which is a Norwegian case, where there was something similar to ground rents. So not exactly ground rents, but there's the closest thing we've got, I suppose, to that. And initially, the state in that country sought to regulate to abolish those, to basically reduce their value to zero, if you like. And following exhausting the local, the national court process, the case went to Strasbourg, and And ultimately, it was held that you couldn't just simply abolish these rights altogether. But if you were able to control the use, if you were able to restrict the value, and I think in this case it was effectively equivalent to, say, 0.2% of capital value in the rental income that was being received, then that would be fine. So where we're going ultimately in this, if this does get all the way down the line into a further human rights argument, will be a bigger argument about has it got, does this statute go too far? And of course, the freeholders will say that it does because it deprives them of their income. One of the freeholders making the claim is a John Lyons charity. They'll say, we're not getting the enfranchisement income we would have got, or once this comes into force, we won't get that, so we can't fulfill our charitable objectives. Now, I know this becomes quite political. People on both sides have got very strong views on this. But the job of the courts ultimately is to try to interpret the law to make it work for the benefit of those in front of them. And so we're at this first instance, if you like, attack on the process of passing legislation. Legislation is not even actually actively enforced. And the position of the freeholders is to say, well, look, the mere prospect of this legislation sitting there has actually damaged the value of our assets.
Well, there's a valid argument. I mean, here we are doing a podcast talking about a reform which is on the books but not active at the moment, but it's still important enough that here we are spending time with cameras and producers and things talking about this.
Yeah.
They do have a point, I think.
Well, absolutely. There's a real transfer of value that this law will bring about. And I think, that's a political consideration. Parliament's passed a particular piece of law. This is, I suppose, the last potential stop in terms of working out whether this law will actually be effective or not, or indeed in an extreme case whether there might be a compensation argument. Now, of course, the government wouldn't want to get into that position, but we are just at this position now where the initial argument was, well, there's nothing to see here because we've passed the legislation, and the court said, well, no, there is enough to have a look at this. So what this has meant, and the practical point of all of this, I think, is until we know what the outcome of this case is going to be, and we do expect a decision fairly shortly on this initial judicial review, potentially imminently. So there was a case heard from the week commencing the 16th of July, 4 days in the High Court. We expect a decision potentially before the end of September or the beginning of October. But even if that decision says, well, this is fine, it's quite possible that there'll be a further appeal. And it's quite possible if the decision goes the other way that the other side are going to appeal. And there's then also the possibility of this moving on in a human rights space, obviously into Strasbourg or beyond. So there could be some significant delays to the implementation of this legislation. And we don't quite know how that's going to play out. So I suppose you and I both advise people in practice on this sort of stuff all the time. And I think the key question now is really, well, what should I do?
Well, it's difficult, though, because obviously our entire job is to look at the framework of the law, look at the current market and the forces that we're all dealing with, and try and give clients the best selection of curated options. And I think you and I are having difficulty here, though, because we honestly don't know when or if this reform is finally going to hit the statute books and be relevant. I mean, obviously we can talk about it and say, well, this might happen in the future, but the next question invariably is, when?
Well, quite. And that's, I think, the big question. So that, do we think it's going to be 12 to 18 months down the line? Do we think it's going to be a year? Do we think it's going to happen that a decision's going to come out, the government's going to go, actually, you know what, I'm going to be really bold about this. We're just going to march on with this and let's see what happens next. Because there's kind of two bites of the cherry. The first bite is in this pre-implementation phase. There could be another bite when the legislation's actually been passed, because in human rights terms, normally you're seeking redress because your rights have been infringed by an act that has been passed. Whereas here we're just in a situation where the act on the statute was not actually in force yet. So there could be other things done in commencement. Let's step back as well and look into the technicalities of what's gone on in the background. So the government promised a whole bunch of consultations in November of last year, some of which have taken place. Some of those relate to service charges, some of those relate to insurance commission and other things. In addition, to bring forward the enfranchisement reforms, the ones that we've talking about that would change the capital value that's used in working out the compensation calculation, there would need to be a consultation on two key rates, the capitalisation rate and the deferment rate. And that consultation would need to take place before the active parts of this legislation be brought in. And what's been said by government is, well, we won't bring that consultation about whilst this case is ongoing, until we know where we are. So you can certainly pretty much hang your hat on the fact that unless we get to a definitive point in the challenges at the minute, there won't be the consultation on rates. If there's not the consultation on rates, it's hard to then see how you can get on with the implementation of the remainder of the reforms. Of course, this is all to be played for. We are going to see this play out in the next coming weeks and months. But is there going to be a sudden change? The answer is no. And I think that has a telling sort of point for people who might then be moving close to a watch point in the current valuation mechanism, which is 80 years and lifetime of the lease. So, we may be seeing more of that.
It's difficult because we can sort of be like a one-eyed surveyor, though. We can see something down the line. We have no idea how far away it is, though, but it is a seismic shift to the entire structure. I mean, I suppose sympathy isn't the right word, but one can understand the frustration of peoples who may have undertook many years ago investment strategies, freehold acquisitions, thinking, well, this will pay out at some point, only to see that it is completely wiped out by a political headwind. You can understand the frustration, certainly why they're putting their money where their mouth is and bringing a clap challenge in the High Court. But I think we've spoken about this previously on other podcasts, that there is a possibility that this will basically be leapfrog in either way up to the Supreme Court, and even beyond that. Though,
I think that's got to be the next logical step, hasn't it? Because I think you need to exhaust all national remedies before you can start looking beyond the borders of the country itself. So I think that's quite possible. Absent any sort of seismic shift in the position. The other thing that might happen, and once again, this is purely speculation, no knowledge of this whatsoever, but there is the promise of further legislation. And so we've got a new government that it's going to consider some steps in the common hold direction. Does it then want to do something different in this space as well? That would be possible. I'm not saying that that's likely, but there are some other things that could happen. And I agree with you, Charlie. I think people that invested in freeholds, for instance, as collectives who bought out somebody who had a shorter lease, had the expectation at some point that someone would buy in, they get their money back. It's something the Law Commission looked at. And one of the things that was looked at when the legislation was put through, should there be a difference based on who you were? If you were a charity, should you still have these rights preserved? If you were a private individual or a collective that had invested in your freehold, would you have a different position to someone as an external third-party investor that's done this for commercial gain? But I think, perhaps rightly so, for legal certainty, it's very difficult to then make those points.
You can't. I find it uncomfortable, the concept of creating a different subcategories of leaseholders or investors in leasehold property, and then say, well, you get special rights, but you don't. But my discomfort with the idea doesn't mean it's not going to happen, though. It is already enshrined in various laws.
Well, let's look at the Building Safety Act.
So
it depends what they were doing on the 14th of February 2022.
The intention was that particular act, which we all love, great work, is there to protect the man on the street who buys his leasehold property, but they needed to put a cap. They didn't want large institutional landowners who own hundreds of leases. But the problem is, well, how many is enough? Is 2, 3, 5?
Yeah.
It's difficult. Where do you draw the line?
Well, it's like the boundaries in enfranchisement about qualifying leases, isn't it? Once again, stop investors buying up properties by using it as a stalking horse to get an objective. So you can have 2 or more flats in the same name. Actually, you can get around that. The building safety is slightly different. But I think, perhaps rightly so, it's difficult to focus in on who the actual owner is. I think this probably opens it up to abuse, and therefore we're back in the situation where government said, well, look, we're going to implement these reforms. It's not going to matter whether you are extremely wealthy or whether you are somebody who's invested money as part of buying a collective. It's going to be the same change for everybody. I'm sorry, that's just the way it is. I mean, if you ask me a personal view on this, and this is something which is not in any legislation.
I was just about to ask you this, actually, though, because I was going to say, because I think you are one of the first leasehold specialists. I mean, you set up the landlord and tenant team of Bishop Sewell, didn't exist before you. So you've been this has been your bread and butter for a long time. So what do you think of these reforms?
Well, I think, obviously I'm all in favour of a workable system. Something that all of us said a long time ago was, if you're going to bring about reform, make it wholesale reform. Don't make it piecemeal. Don't do further sticking plasters. Do what the Law Commission was suggesting, reform the whole system. That's something which the government has made a pledge to do. But that's a very, very big piece of statutory undertaking. I think the other thing, you look at the current reforms, and I'm not in government, but if you want to make the sorts of changes, the value changes, the shifts, the adjustments, which this unimplemented act suggests you should do, surely the better way would be to phase in implementation so that, for instance, marriage value doesn't disappear overnight, but the 50% marriage value to somebody with a lease of under 80 years is maybe switched off slowly. So it would go down from like 50%, 40%, 30, 20, maybe do it over 5 years, 10 years. There's lots of ways you could do that. In the same way, you could slowly bring in the implementation of the 0.1% cap on capital value, if that was your long-term plan, because those things won't cause a sudden market adjustment. As it sits at the minute, the legislation will immediately hand value into the hands of people, let's say, with short leases. Now, that might be a very good thing, a very sort of worthy thing to do for people that are stuck financially and are in this position through, inverted commas, no fault of their own. But it has to be borne in mind that a lot of people who profit from this are people who are immensely wealthy, who've got short leases in central London. So is that the best use of taxpayer money? I'm not sure it is, but that's not for me to decide. That's for government to decide.
So you would have preferred a situation where everyone gets their calendars out and marks down, so this is second quarter goes down to 50-75%, and then a bit more,
maybe
a bit more generous.
I think the thing is, because you're looking at something that's having an impact on the market. So rather than doing something suddenly with an abrupt stop, you just make a general change. And I think it also allows investors to then decide to divest themselves from the asset class if that's what you want them to do. It allows the market to change and for there to be a natural transfer of value if that's what Parliament has in mind. I think you have to go back to the bigger point, though, come back to where we went in on this with a judicial review point, which is that if you're going to go so extreme with your reform, you've got to be careful that you're not taking all of the value away. I mean, the whole point about that was the discussion about removing ground rent in its entirety, which was something that was talked about. So just turning all ground rents on whatever leases to be a peppercorn from tomorrow. If you do that, of course, it's possible to pass a law that says that. There's an immediate switch off in value. And once again, that's just going down the route of state appropriation. It's just going too far. So there has to be a balance. So, thank you very much for asking me the question.
Please tell me there's going to be no more reforms coming down the line. I can't cope anymore.
I wish I could say that, but I'm afraid we'll be back for another episode.
Well, thank God the government is invested in having a decent housing secretary.
Indeed.
We'll see how it goes. Mark, thank you very much.
Charlie, thank you.
That's all for today's episode of Listen Without Prejudice. Whether you're navigating a property transaction, a corporate, commercial, or family matter, we're here to guide you every step of the way. If you enjoyed the episode, don't forget to subscribe to stay up to date on future episodes, where we'll continue to explore the latest trends and challenges across our core practice areas. Do you have a question or topics you'd like us to cover? Or do you want to reach one of our experts? Feel free to get in touch via LinkedIn or through our website, bishopandsewell.co.uk. Thanks again for tuning in. Be sure to join us in our next episode, where the conversation continues. Until then, take care.